Hi, my name is Easton Lewis, and today I'll be discussing Chapter 3, which is the American legal system. At the beginning of this chapter, it describes what jurisdiction is. And a jurisdiction is simply the power of a court to hear a case and render a binding decision. There are forms of jurisdiction, and the first one is the original jurisdiction, which is also known as a trial. And this is the power of a court to hear a case and render a binding decision. The second is the appealing jurisdiction, and this is the power to review a decision previously made by a trial court. These forms of jurisdiction refer to the role the court plays in a judicial hierarchy. The chapter goes on and describes what jurisdiction over persons and property is, which is also known as in personam jurisdiction. And this is the power of a court to render a decision that affects the legal rights of a specific person. In this jurisdiction, people are specifically classified. A person who files a lawsuit is known as a plaintiff. The party against whom an action is being brought to is known as the defendant. Going on with the second step in the legal process is to provide the defendant with the complaint and summons. The complaint is a detailed statement that states the plaintiff's lawsuit and the relief being sought. A summons is an order of the court notifying the defendant of the pending case and telling him or her how and when to respond to the complaint. The topic continues by introducing what a long-arm statute and in rem jurisdiction is. A long-arm statute is a statute authorizing a state court to obtain jurisdiction over an out-of-state defendant when the party has significant minimum contracts with the state. In rem jurisdiction is the power of a court to render a decision that affects property directly rather than the owner of the property. The chapter continues with discussing the subject matter jurisdiction. And the subject matter jurisdiction is the power of a court to render a decision in a particular type of case. These particular type of cases are known as state jurisdiction, exclusive federal jurisdiction, and concurrent federal jurisdiction. State jurisdiction applies to cases that may be heard only in the state court systems. Exclusive federal jurisdiction applies to cases that may only be heard in the federal court systems. And then lastly, the concurrent jurisdiction applies to cases that may be heard in either the federal or the state court systems. Continuing on with the chapter, it describes what a venue is. And this is the location of the courts conducting the hearing as prescribed by the state statute. And the venue location is based on the residence of the defendant, the location of property in dispute, and the location in which the incident of the dispute occurred. A change in location can occur if parties of the case request is moved under the doctrine form of non-convenience. And then next, the chapter goes on to describe the actors of the legal system and their relationship. First is the attorney. They are the legal representations of the party before the court. To go along with the attorney and how their relationship goes along with the attorney-client privilege. And this provides the information furnished by a client to an attorney in confidence in conjunction with a legal matter may not only be revealed, but the attorney without the client's permission. And then 3 is the work product doctrine. And this provides that formal and informal documents prepared by an attorney in conjunction with the client's case and privilege and may not be reviewed by the attorney without the client's permission. And then the second actor in the legal system is the judge. And there are 3 types of judges. The first one is the appealing judge, and these judges serve on panels and review lower court cases. The second is the state court judges, and these judges are either elected or appointed. And then 3, the federal court judges. And these judges are appointed by the president with advice and consent of the Senate. Judges are important because they have power of judicial review. And judicial review is the power to determine whether a law passed by legislative violates the Constitution. They also go along with the judicial restraint, which is when courts refrain from determining the constitutionality of legislative act unless absolutely necessary. And then also judicial activism, which is when courts take an active role in encouraging political, economic, and social change. And then the second actor in the court system, going back to the slides, is the jury. And there are two types of juries. And the first one is the patent jury and the grand jury. And the jury is simply just a random selected group of individuals in which the court is located. So going back to the patent jury, it's a jury of 12 citizens, and these citizens decide on the facts and issue in a criminal case, and they ultimately get to decide whether the defendant is guilty or not guilty. And then the grand jury is 12 to 23 citizens confined in a private, decide whether enough evidence exists to try the defendant for a felony. And then going along to the adversary process, this is when judges hear evidence arguments presented by both sides in the cases. He ultimately makes an object decision based on the facts and the law as presented by each side. Although this is a system used in the judge, there's some criticisms that go along with it. And this system has a tendency to ignore contrary evidence, prevents a fair decision from being rendered. It's extremely time-consuming and costly, and certain parties tend to have a distinct advantage. And then going on is the steps in the civil, legislative, and the role of business persons. And the first stage is the pretrial stage. And the rules of civil procedure is defined in these, and the rules, and that is the governing proceedings in a civil case, and then informal negotiations, which is discussing the dispute directly with the other party, and then initial of legal action, and this occurs when an informal resolution is not possible. And then it goes on with pleadings, which is papers filed by a party in court and then served to the opponent in a civil lawsuit. Service of process is the next topic in the pretrial stage, and this gives a court an in personam jurisdiction over the defendant. This just provides the notice of the charges required by the defendant's due process rights. And then the defendant's process is either a motion to dismiss or a counterclaim. And then going on with the pretrial stage, a pretrial motion is the party's request for a court action, and then a copy is sent to the opposing attorney. Discovery, which is a pretrial gathering of information by both the parties from each other. The tools used is ignoratories. I might butcher that, and then requests to produce documents or other items. And then disposition is a pretrial testimony by witnesses examined under oath. And then the last in the pretrial stage is a pretrial conference. And this is held if the judges finds that the questions of fact exist. This pretrial conference discusses the informal meeting of the judges with the lawyers representing the parties. Settlement is worked out if possible, and then determining the limits of any settlement is necessary prior to the pretrial conference. And then the next is the actual trial. And then during this process, the jury is selected. It's selected through a process called voir-dire. I hope I didn't butcher that as well. And then a mock jury is formed, which is a group of individuals in front of whom the lawyers practice their arguments before presenting the case to the actual jury. And then the shadow jury is the group of individuals that sit in the courtroom during a trial. Going on with the trial, the opening statements are heard, and this means just each party of the attorneys explain to the judge and the jury what facts he or she intends to prove and the legal conclusions to which these facts will lead, and how the case should be decided. The plaintiff's case is which is the direct examination. The plaintiff's attorney asks questions that supports the plaintiff's case. And then the redirect examination during the trial is when questioning by the directing attorney following cross-examinations. During this process, they scope out the questions, is limited to the questions and asked in the cross-examination.